in New York and Geneva. We're still waiting for a couple of panelists, but they will join us in due course. My name is Francesca Mingrone from the Center for International Environmental Law, and I have the pleasure of moderating this panel. This side event is co-organized by the Permanent Mission of the Republic of Vanuatu, the Permanent Mission of the Republic of the Marshall Islands, the Permanent Mission of Costa Rica, and with the support of the Office of the High Commissioner for Human Rights and the Center for International Environmental Law. This event builds on previous ones that have been organized in the past weeks and months to really unpack the key content of the advisory opinion on climate change by the International Tribunal of the Law of the Sea, the Inter-American Court of Human Rights, and the International Court of Justice. For today's event, its focus will be on the opportunity offered by the International Court of Justice advisory opinion and the way in which states and UN mechanisms can really build on it. I have the pleasure to introduce you the panelists. We have His Excellency Ambassador Sumboe Antas, the Permanent Representative of the Republic of Vanuatu. Her Excellency Ambassador Doreen de Broom, Permanent Representative of the Republic of the Marshall Islands. His Excellency Ambassador Carlos Soreta, Permanent Representatives of the Philippines. Her Excellency Deborah Marie Gills, Permanent Representative of New Zealand. And we are also waiting for Astrid Fuentes, the UN Special Rapporteur on the right to a clean, healthy, and sustainable environment, and Elisa Morgera, the Special Rapporteur on climate change and human rights. They are here in Geneva just for a few days, and their agenda is very packed, as you can imagine. Without further ado, I would like to hand the floor to Ambassador Antas for some opening remarks. Thank you.
So thank you very much, and good afternoon to everyone. Welcome to the side event. I know that the side event to them, we hope that this will not be the first. This will be the first of many to come in the coming years within the UN systems here. We are very honored to co-host today's dialogue on human rights approach to implementing the climate advisory opinion, which was issued by the International Court of Justice on the 23rd of July 2025. But this ruling, plus other rulings from the International Tribunal for the Law of the Sea, the Inter-American Court of Human Rights, have transformed the landscape of international law on climate change. And together, they affirmed that states have clear legal duties to prevent climate harm, to protect human rights, and regulate the private sector, including the phasing out of fossil fuels. The IACtHR further confirmed that failure to act, whether through licensing, subsidies, or weak regulation, can amount to an internationally wrongful act. These opinions are not abstract. They speak directly to the lived reality of people in Vanuatu, as well as across vulnerable regions around the world. Rising seas, stronger cyclones, slow onset loss of territory are not just environmental issues. They are human rights. And if it does happen, they are human rights violations. That is why accountability is at the heart of today's discussion. Thank you.
Thank you very much, Your Excellency, and also welcome Professor Morgera. Thank you for joining us. Your opening remarks have really helped us set the scene to this event. As I was saying, we have already organized a few events to unpack and analyze some of the key elements but we thought it would be helpful to provide a basis for today's discussion to recap some of the main findings of the advisory opinion, and also the ambassador already highlighted some of them. First of all, the ICJ has applied a harmonious interpretation approach and explained that states' obligations under international law concerning climate change extend beyond the climate change treaties and do include customary law, human rights law, and the relevant environmental treaties. The court also stated that the duty to prevent transboundary environmental harm is fully applicable with respect to the climate system and must be performed under a stringent due diligence standard. And he has also added that due diligence is guided by the principles of equity and common values, differentiated responsibilities and respective capabilities, and is informed by the best available science and may also evolve over time. Importantly, the court affirmed that the right to a clean, healthy, and sustainable environment is a binding norm of international law, and we will hear more from the Special Rapporteur on the right to the environment on that. With regard to mitigation, the court reaffirmed that global temperature rise above 1.5 degrees Celsius is not safe for most nations, and also specified that when states define their nationally determined contributions, they have to exercise due diligence and ensure that the NDCs, when taken together, are capable of achieving the temperature limit of 1.5 degrees. It also acknowledged, as the ambassador was saying, that burning of fossil fuels is a leading cause of climate change, and we will hear more about that from Professor Margera, I'm sure, and also that states are obligated to prevent climate harm. And it added that failing to curb production and use of fossil fuels as the main driver of climate change may violate international law. He also made it very clear that states have an obligation to regulate the conduct of public and private actors within its jurisdiction of control. And interestingly, which is also very relevant to a resolution that is being discussed before the Council at the session, with regard to sea level rise, it did mention that when territorial integrity is harmed and undermined by sea level rise, these does not legally affect the maritime boundaries. And also, even if the effects of climate change result in the complete loss of territory and the displacement of its population, a strong presumption in favor of continued statehood should apply. And finally, the court looked at the consequences of violating legal obligations. This is also something the ambassador touched upon, really affirming that any breach of legal obligation of states in regards to climate change does trigger the full range of legal consequences under the international law of states' responsibility, which includes cessation or repetition, reparation, and compensation. These are to make good justice to a very long and comprehensive advisory opinion, but we thought it would be useful to reiterate some of the key findings as they will inform the panelists' intervention. I have the pleasure now to hand it over to Ambassador in the room. So we're talking about, of course, the legal finding of the advisory opinion, but how do we turn this into action? And specifically for small island states like the Marshall Islands, what would you like to see happening now, now that we have the advisory opinion? Thank you.
Thank you, Francesca, and thank you, Ambassador Antas, for your opening remarks. You've asked me to speak about what small island states would like to see happen next, now that we have the advisory opinion. Excellencies, ladies and gentlemen, friends, colleagues, fellow panelists, good afternoon to all of you. It's a good question because, of course, for so long, all of our attention was focused on getting to the point where we have an advisory opinion. And I have to say, once again, a huge congratulations to the students from the University of the South Pacific who began this remarkable campaign with that wonderful catchphrase, and I quote, "Let's bring the world's biggest problem to the world's highest court," end quote. Their achievement is remarkable. And we all thank Vanuatu for hearing their voice and amplifying it in New York. What incredible young people. I was lucky enough to go to The Hague this summer and hear the ruling for myself. It was an overwhelming moment to sit there and hear the world's highest court play back the very same words, the very same truths that we in the Pacific had been speaking for so long. It felt almost surreal. It is a momentous ruling, and one Francesca and Ambassador Antas have summarized clearly for us. But we can't let it sit on paper. We need to turn it into action. And the time is tight. But we're not starting with nothing. We have some powerful instruments in our hands, tools of consensus, like the UNFCCC, tools of science, like the IPCC, and we have the Paris Agreement, something that we once called a lifeline for small island states. These are instruments of great power if we can use them to their full potential. It's no secret that small islands have been frustrated by the slow speed of progress. So we need this advisory opinion to inject the urgency that had been missing for so long. To begin with, let's start with the emissions pledges, or NDCs, as we call them in the Paris Agreement. The ICJ told us that emissions pledges aren't just voluntary offerings. Instead, countries have a legal requirement to submit pledges that reflect their highest possible ambition and ensure that they are compatible with the 1.5-degree pathway. So as countries prepare to gather in Brazil this November for the COP and renew their emissions pledges, we need to see the highest standard of accountability. We can no longer be asked to be grateful for lukewarm promises or take, let's say, fossil fuels, which we know we must leave behind us. The ICJ confirmed that continuing to extract, use, and subsidize fossil fuels may constitute internationally wrongful acts. Countries already promised to move beyond fossil fuels 2 years ago in the global stocktake in Dubai. So we need to see them come to Brazil communicating clear paths for how to make that happen. The other priority, of course, is climate finance. The court tells us this isn't just charity. Countries who have caused harm are required to make good on their actions. So it's vital to see rich countries coming forward with accessible and fit for purpose climate finance, including for loss and damage at a much greater scale. And we have work to do here in the Human Rights Council as well. The sad reality is that for many island and coastal communities in all parts of the world, the enjoyment of many human rights is tied and linked to climate change. And it was important for us to hear the ICJ confirm that too. As I have said before, I invite anyone who says that there's not a role for climate discussions in the Human Rights Council to go and please read the ICJ decision. Please read it and please join us, because we have important work to do. We have a wonderful cross-regional network of ambitious states here in Geneva. And I know the Pacific states won't be the only ones stepping up, which is important, because we have some of the smallest delegations trying to cover multiple issues at once. But armed with the ICJ decision, I'm confident we can see the Human Rights Council reach new levels of ambition. Como Dada, and I thank you.
Thank you very much, Ambassador De Broom, also for giving us some homework so we know what we will be doing this weekend, downloading and reading thoroughly the advisory opinion for those who haven't done yet. Turning now over to Ambassador Giles, we have heard from Vanuatu, from the Marshall Islands, and New Zealand is also a member of the Pacific Island Forum. So it would be very interesting to hear, as a member of the PIF, as a developed nation, what are New Zealand's broad reactions on the advisory opinion? Thank you.
Thank you very much, Francesca. Who can forget the iconic image of Tuvalu's foreign minister standing knee-deep in the seawater as he gave his address to COP26 in 2021? A really stark demonstration of the critical threat that climate change poses to the very existence of small island countries like Tuvalu. No wonder then that Pacific states have been at the forefront of global calls for climate action across a whole range of fronts. And I want to thank the organisers of this event here today to create the space for us to have dialogue on this really important issue. I'm just going to talk a little bit about what's at stake, how did we get to the advisory opinion, and then what does it mean? Adding to what we've already heard from some of the panelists today. So what's at stake? For 12 million people across the Pacific, climate change is the single greatest threat to their livelihood security and well-being. And Doreen has already referred to some of those impacts, but it includes the loss of land, displacement of people, impacts on food security and on health, and threats to the maritime zones that were established under the United Nations Convention on the Law of the Sea. So that existential threat nature of it is recognised in a number of regional frameworks in the Pacific, including the Boy Declaration on Regional Security and the 2050 Blue Pacific Strategy. And at their most recent meeting in Solomon Islands just last month, our Pacific leaders commended the advisory opinion on climate change as a powerful affirmation of what the region can achieve when it works together. So how did we get to the advisory opinion? New Zealand has supported this work right from the beginning, and we've been very proud to be a member of the core group led by Vanuatu that developed the UNGA resolution that requested the advisory opinion from the ICJ. The consensus adoption of the resolution, I think, speaks volumes to the crucial importance of the issue, but also the very hard work by the core group. And I want to acknowledge in particular, as others have done, Vanuatu's leadership here and also the advocacy of the Pacific Island Students Fighting Climate Change group mentioned by Doreen. So what does it mean? The advisory opinion provides a valuable contribution to states' understanding of some very complex issues that have been highlighted by Francesca, and the actions that states need to take in fulfilment of their legal obligations. Particularly significant to our work in the Human Rights Council are the court's findings related to states' human rights obligations in the context of climate change. The court also reinforced the Pacific Island Forum's work on sea level rise, confirming that statehood and sovereignty will continue despite rising sea levels, consistent with the Pacific Island Forum leaders' declarations in 2021 and 2023. And as others have said, the advisory opinion is not the end. It's the beginning now of a new phase. Implementation will bring both challenges and opportunities. We can't, as Doreen said, just let it sit on paper. It will require international cooperation and constructive engagement guided by international law. Today's discussion has already generated some ideas, and I'm sure we're going to hear some more from our special rapporteurs. I'm looking forward to hearing them. But we need to talk together and build on those and turn them into action. And in conclusion, I think as Tuvalu's Foreign Minister reminded us 4 years ago, the threat of climate change is a universal one. International cooperation is critical, and New Zealand looks forward to further discussions here in Geneva in the context of the Human Rights Council, but also in New York on the advisory opinion. And we call on everyone, state, civil society and others to engage constructively on next steps, guided by international law and shared principles. Thank you.
Thank you very much, Your Excellency, and indeed, Pacific leadership behind Vanuatu's key leadership has been key really to achieve the advisory opinion, but I would also like to acknowledge here the role of the Pacific youth supported by a global youth movement that was also essential to keep the momentum high and also win the hearts of the global community. We changed partially region, although we're still the Asia Pacific, over to Ambassador Sorreta. We've heard that human rights are central, of course, in the advisory opinion. And so I would be curious to hear your perspective on the key human rights dimensions of the advisory opinion. And also, how do we foster synergy between UN institutions for multilateral action on the advisory opinion? We heard already talking about the Human Rights Council, the top, so grateful for your perspective. Thank you.
Thank you very much, Francesca. Good afternoon, everyone. I'm very happy to be here. And like Sambu, Doreen, and Deborah have said, essentially, this case is not abstract to those of us who are affected. Last week, we were hit by another super typhoon, 3 dozen people dead, millions in damages. It's another typhoon on the record, the strongest this year. Philippines holds the dubious reputation of being hit by the top super typhoons since the start of recorded history. So it's and in between, when we're not being battered by typhoons, we're being ravaged by drought. So it's extreme climate events in my country. So it's not like Sambu said, it's not abstract. So it was with great determination and honor when I was lead counsel for the Philippines in the ITLOS advisory opinion and was counsel and argued before the court in the ICJ opinion. I think I'll start off by saying by talking a little about where the court is now in terms of its juridical philosophy and attitude. When the court first started, its first decision, which is the Corfu Channel case, relied very heavily on customary law, on subsidiary sources of international law, the writings of publicists, the decisions of the PCIJ. But since then, today, the court is more positivist, meaning they rely very heavily on conventional law. And there's reason for it. Since 1946 to today, there's been over 560 multilateral treaties registered with the United Nations, with the UNSG, and many bilateral agreements. So there's a wealth of very clear norms for the court to be using over 80 years. So why is that important? Because if you look at the decision of the court, the sources that they cited for authority are conventions, decisions of the court, issuances of bodies of the United Nations, and they have stayed away from citing experts, legal experts, not the climate change experts, but the legal experts. So they've cited resolutions, both the HRC and the GA. And what does this tell us tactically? These are the areas where we need to work on because these are the sources of law for the court is using. So we look beyond the decision and we see that, and that's where we should be going. And one of that is human rights, and particularly how it interacts with the other norms. It seems that the court has kind of determined that there is some hierarchy in terms of norms as listed in Article 38 of the statute, the first of which is conventional law. So that's where they start off with charter and then the climate change agreements. So a very important thing the court did was to take away the silence, not give in to the arguments of some of those who were there in The Hague, that there is that the lex specialis applies, that for example, the Paris Convention is a self-contained regime, that everything that if there are breaches, it should be resolved within the norms of that convention, that there's that the drafters did not intend, for example, the human rights to apply or any other norms outside, so that it's self-contained, which is usually the case, that you must observe the intent of the drafters in interpreting. But the court opened the door to allowing human rights to walk in, and so that even if you are observing the Paris Convention, but there's objective harm, and there's violation of human rights. You may not be in breach of the conventions themselves, but if the objective harm continues of your actions, then and it violates human rights, then there is state responsibility. The problem with the conventional framework is that it's regulatory, it's not prohibitive, meaning it did not say you must cease this harmful activity, you must cease this internationally wrongful act. No, it did not. It's like the Non-Proliferation Treaty, in essence, that we have a treaty that does not prohibit but allows certain countries to continue to have nuclear weapons. So we have this situation, and the solution is really to go to human rights and to customary international law to strengthen that. So the next steps are very important. I know there's a resolution that's going to be sent to the UNGA. It's very important that we handle this very carefully because we need to prevent, if possible, the states will use it as a platform to be persistent objectors to the development of the customary norm on the right to a healthy environment. So you will, those of you who know customary international law, it's composed of two elements, the state practice and the opinion yours, which is the belief that it is legal, and persistent objectors. Although the court has had mixed rulings on this, states always try to use platforms to project that they don't agree that this is a norm or that it is developing as a norm. So my human rights expert is signaling me that I have no more time. So I'll wrap up. There are far-reaching implications in terms of human rights and the court's decision generally. For example, on the territoriality of human rights, when the human rights conventions were negotiated, it put the obligation on state parties towards their nationals or people within their territory, because they don't have to care too much about the people in other territories or state parties, because that's the sovereign responsibility of the other state. So there's a play there on Article 2, Paragraph 7 of the Charter, where you leave to sovereign states their obligations under international law and you don't interfere in it. But the court, I'm still trying to understand it better, but the court said no, human rights are not limited by territory, and therefore harms created in one state. Oh, by the way, just as a note, the Corfu Channel case is the first one that said that states should never use their territory to harm others. So that's where this some of the norms evolved. So the court, that's one far-reaching implication for human rights, that it has a good and it works both ways. The other big implication is it widens the application of human rights to other conventions by saying that the climate change conventions are informed by human rights norms. Then you can also say it should inform other conventions. For example, in disarmament, for example, on development, on finance, on migration, it strengthens the human rights element now to come into this. And I think that we should be able to work on this. So there's many legal and just one word. The problem now is when the court closed its decision, it kind of went back to their advisory opinion on the nuclear weapons case, which said that if states want to eliminate climate change, they should come together and agree on a treaty. Because in that last paragraph, the court, it said, it's up to states to come up with the action, with the necessary action to end climate change. The court, it said, can only do so much within its mandate. It cannot do what states on their own, as sovereign states, should do if they want to. And so we have to try to convince states that they want to save the world and save the people from climate change. Thank you.
Thank you very much, Your Excellency, for a very rich intervention with electromagnetic studies in 5 minutes. You touched upon many points that I'm sure the next panelists will also unpack, whether it's on the right of the environment, the consequences once obligations are breached, the question of transboundary harm and extraterritorial obligations. And thank you also for recalling the final part of the advisory opinion, really stressing the importance of international cooperation and solidarity to tackle this global issue. I would also like to use the opportunity to welcome Ms. Fuentes. Welcome to the panel. Thank you for joining us. So we are heard by Ambassador Giles and others that the ICJ is not the end, but it's the beginning. So now turning to Ambassador Antas. You have been leading, of course, the efforts towards the advisory opinion, but now you have some other initiatives cooking, and Ambassador Sorreta already mentioned the potential initiative of the GA, for instance. So how to move forward and ensure a concrete follow-up on the advisory opinion? Thank you.
Thank you again and good afternoon. For Vanuatu, state-led initiatives have always been driven by a sense of urgency. Our people, and this was reaffirmed this week when the mission of Kiribati was opened here in Geneva. And the president of Kiribati spoke to those who were present at the time. And he said, our people stand on the front line of the climate crisis, and with all of us, most of us, the Pacific. Many of us here in the room also. And as has been said, it's a lived reality that inspires us to champion the request for the ICJ advisory opinion. Today, we continue to lead efforts at the UN General Assembly for a resolution that will endorse and operationalize the court findings. And my colleague Ambassador has said there's a lot of work that we must do, while also recognizing the complementary contributions of the International Treaty of Law at Sea and the InterAmerican Court of Human Rights decisions. So those are very important and complementary part of the work we need to do ahead of us. But accountability cannot stop at the international level. Implementation must be pursued at home. So we in Vanuatu are actively working to integrate the clarifications from these advisory opinions into a domestic climate policy, including our updated nationally determined contributions. And Vanuatu has just issued its third version of the NDCs last week on Thursday. I have not yet read it, but we'll have some time to read that. But we are advancing the recognition of the right to a clean, healthy, and sustainable environment, and through a constitutional amendment that is now before the Council of Ministers, and an initiative that we are also advocating for across the Pacific. And for us, accountability means ensuring that the legal principles affirmed by the ICJ are translated into real enforceable commitments at the global level, in our region of the Pacific, as well as domestically. And this is how we can uphold the rule of law in climate action, safeguard the rights of present and future generations, and ensure that no state can turn away from its responsibilities. The ICJ opinions are clear. States have legal obligations, and accountability must follow. The UNTA resolution is an opportunity to strengthen the responsibility framework, confirming that wrongful acts and actions include failure to regulate emissions of fossil fuels, which are reminded the last paragraph of the ICJ's opinion, mandating reporting and review through UN human rights bodies, and ensuring remedies are pursued for affected communities. So mandating reporting and review through UN human rights bodies would like to keep pushing this as part of the human rights work here in Geneva. Accountability is essential not to punish, but to protect. to ensure that human rights of the most climate vulnerable are no longer disregarded. Looking ahead, we see both New York and Geneva as critical partners in the implementation of the advisory opinion. Our New York missions are leading on negotiations on the resolutions to endorse the advisory opinion. But the Human Rights Council, its treaty bodies, and special rapporteurs also provide complementary mechanisms to translate legal clarity into action, especially if we are looking at human rights approaches to implementation. Together, New York and Geneva can ensure that international laws clarification are embedded in both global frameworks and national implementation. I thank you.
Thank you, Your Excellency, and also, thank you for reminding us of the importance of Geneva and also informing these processes. It's very interesting to see the extent to which the advisory opinion mentions resolutions by the Human Rights Council treaty bodies, as Ambassador Sorita was saying. Also mentioned one report by former Special Rapporteur, and this is a perfect segue for me to give the floor to Professor Morguera. In your perspective as Special Rapporteur, we've heard, of course, of the need to break silos and further collaboration across avenues. So what is your take on that? How can states and civil society better work together between New York and Geneva and beyond? Also looking at the COP, for instance, in a couple of months. Thank you.
Yes, thank you so much to all of you for allowing us to continue, I think, an ongoing conversation on the advisory opinions here in Geneva, but also thinking about connections and respective roles and opportunities across the UN system, and in particular in relation to the New York processes. I think that aspect of the harmonious interpretation of international law is crucial. This is something that, of course, the Human Rights Council, the Office of the High Commissioner for Human Rights, and several special procedures have contributed over time. And as special rapporteurs, we already started including in our work the earlier indications from the ITLOS advisory opinion that was very much confirming this approach, which we've seen flourishing in the advisory opinion of this year. And we will continue to do so. And the idea is that our advice can both show that alignment of several sources of evidence and best available science, climate science, but also biodiversity science, health science, and crucially, the lived experiences and human rights evidence that all point in the same direction of the most meaningful climate action that can effectively prevent further human rights impacts. And it's really important to show how that harmonious interpretation of international law is the only legitimate interpretation of international law in the light of best available science and in the light of what is being experienced by whole populations of states, but also by segments of society in all countries of the world at this stage. And it is really important that we then nurture that engagement, that constructive engagement with that understanding of international law, which had been missing and had been maybe made intergovernmental negotiations in the context of the climate regime, but in fact in other contexts as well. And also that understanding of priorities for international cooperation and meaningful proportionate amounts and quality of climate finance to really see that progress for the whole of humanity towards a safer environment. So there's more work that we need to do there, keep building that understanding and integrating it in the efforts here in Geneva. That's a path that we have started, as I said, and we will continue. In my own case, for instance, my next two thematic reports will be looking at food systems and climate technologies from the perspective of better understanding harmonious interpretation of international law, best available science, and clarify what should be priorities in terms of domestic action and international cooperation on climate change, in particular following up on that now crystal clear clarification from the International Court of Justice that fossil fuel expansion, consumption, subsidies are maybe in violation of international law. And how do we then bring different states into more aligned with that clarifications of international law in the context of very specific national circumstances, respective capabilities. But understanding that right here, right now, all people, and particularly children and other members of society, are being negatively impacted in their rights, particularly as far as health is concerned, by every stage of the full life cycle of fossil fuels. But of course, there's more that we need to do in terms of providing them an understanding of where should we go. And I think the work of rapporteurs in particular, and the collaboration with civil society states in sharing their experiences, their understanding through submissions to our thematic reports, in particular, and of course, engaging in consultations and feedback on the reports, is to clarify where, for instance, international cooperation is not quite supporting that meaningful action, both to support that moving away from fossil fuel dependency, and to really support countries to leapfrog into renewable-based economies, into most effective protection of human rights, and that aspect of the remedies, which I think has been so powerfully clarified with the full panoply of consequences available in international law, very much looking at that as an opportunities for full compliance with what are primary obligations already existing across the body of treaty obligations related to international financial assistance, capacity building, technology cooperation, and making sure that we are prioritizing climate action that is scientifically the one as most effective and meaningful for the climate and people. But in addition, we also have to think about the structures of the UN, and when some follow-up action from the ICJ and the other advisory opinion is needed. And I think thinking strategically about what mandates we can request from the General Assembly through the effort of a new General Assembly resolution that can give rise to more focused processes, particularly here in Geneva, and I think particularly under the aegis of the Human Rights Council, there has been a transformative force to advance that systemic integration of international law in the light of science and lived experiences. And my reports on defossilization already underscore the need to address fundamental issues in international investment law, following up on the work of other rapporteurs, having meaningful conversations about how we advance defossilization and looking at all human rights implications, and supporting any pilot initiative at every level and maximizing the learning. And finally, the question of remedies and looking at how, again, we can look at that as an area of transformation, learning, and enhanced compliance with what are already primary obligations of states that we now understand more clearly.
Thank you very much, Professor Morgera. Hard to recap all the points that you made, but I would like just to elevate the point on fossil fuels. And when we talk about breaking silence, one of the challenges that we face now is to really make sure that our political resolutions that do acknowledge fossil fuels, at least as the key leading cause of climate change, and then corresponding state obligations. Over to another special rapporteur, Ms. Fuentes. So we have heard once again the need to now implement the advisory opinion. So we would be happy to hear from you also about the opportunities, but also challenges in advancing rights-based implementation of this advisory opinion, and specifically looking at the right to healthy environment. Thank you.
Thank you very much, Madam Moderator, and thank you very much for these opportunities. Really an honor for me to be here, and I apologize for being late. I had another commitment, but I'm so glad that I didn't miss much, or not all. So thinking about the opportunities, I think that one of the amazing lessons and opportunities from the ICJ advisory opinion is to remind the world and the clarification of states' obligations, both on the recognition of the right to a healthy environment. We have been talking, and I included in the first report that I did, that the recognition from both the Human Rights Council and the UN General Assembly was not the beginning of the path. at the end of 50 years of work. And so in a lot of ways, I see the same with the ICJ advisory opinion. They recognize crystal clear that, of course, it's unequivocal the existence of climate change and the risk and impact for all states everywhere. Of course, some states, and we heard a lot of examples, are suffering more from these impacts than others. But it's also true that everyone, both in this room and in the world, are already suffering the impacts from climate change. The other key aspect that from the ICJ is the recognition of breaking the silos, even in international law. And it is that it's not, and this is the whole thing, both about procedural, but also in the decision, that international law or addressing climate change is not about one treaty or another, or it's not about one region or another, because it's multi-level. And that's one of the key things, also recognizing the importance of that it's not only the applicable law, but also that it's all international law that exists that can be and should be applicable. And this is also linked with the interrelation and indivisibility both of actions, but also of rights. As we all know, one of the key, very clear conclusions of the International Court of Justice was that the obligation of states to prevent significant harm to the environment, including to the climate system. And they also concluded that this obligation is erga omnes. So it's both included in several treaties that they analyzed, but it's also erga omnes, sending a very clear message to the international community that it's not only about the sovereignty of ratifying and being and maintaining in an international space, but that also, even without that ratification, it's an obligation of all states, that it's very clear. Then the other side of the same coin is the recognition of the right to a healthy environment. So we have from states the obligation to prevent significant environmental harms, including to the climate system. And in terms of people, it's the right to a healthy environment. That they also, the ICJ was very clear to conclude that the right to a healthy environment, of course, exists, and that it's essential and it's vital for the enjoyment of all human rights. They also went further to conclude that the right to a healthy environment is it's essential for states to guarantee all others' human rights. And they also say, one of my favorite sentences in the advisory opinion is that for the court, it is difficult to see how these obligations, talking about state obligations to guarantee human rights, can be fulfilled without, at the same time, ensuring the protection of the right to a clean, healthy, and sustainable environment as a human right. And this conclusion is absolutely key because, again, and I agree with what we were hearing before from His Excellency Ambassador Torretta, that today, although the court didn't say it like that, but some of us, including one of the votes from the judges explaining the advisory opinion, we have to conclude, and we can conclude, that the right to a healthy environment is customary international law, because we have the state practice, and we also have the opinion juries. But it's not a procedural conversation. The right to a healthy environment and the obligation that states have are tools for states to make better decisions and to make sure that they make good decisions. And linked to these obligations, and that's one of the conclusions that also other courts have concluded in terms of the obligation of states, is the obligation to regulate, control, and monitor activities that can cause significant environmental harms, including conducting environmental impact assessments. But they also, the court also, and this was a reminder because there was already a decision before, that it is under customary international law an obligation of the states. And the reason that I'm highlighting that is because we're seeing a deregulation that is very dangerous on environmental impact assessments and other spaces. So implementing this, and this is just realized about the time, so I'm starting to close, thinking about challenges. The economic system in it, again, this is not about a message. We need to change and to implement significant, profound changes for the economic system. It's not because we as mandate holders say it, it's science based, but it's also what we have seen in practice. Environmental human rights defenders also, we as, and I personally as a rapporteur also, I'm significantly receiving constantly from all regions requests to intervene because of harassments or criminalization or attacks to environmental human rights defenders, and specifically, of course, impacts to people that is in more marginalized situations. But we also need to break this silence. It's not one human right more important than the other one, or one advisory opinion more important than the other one. And that's, again, I'm highlighting what the International Court of Justice mentioned is all the body of international law that needs to be implemented effectively. And I will stop there. Thank you very much.
Thank you very much. We never have enough time to unpack. I guess that's why we are multiplying the number of events on the ICJ. Thank you very much for your perspective and also the strong statement about the stages of the right healthy environment. I'm conscious of time. I would like to open the floor for 1 or 2 comments or questions. I see Ambassador Walsh from Australia. The floor is yours. Thank you.
Thank you very much. And I please extend to permanent mission to Vanuatu, Government of the Marshall Islands and Costa Rica for organising this discussion, and all the panellists with very thoughtful presentations. I also want to take the opportunity to express my condolences to the Philippines and to Ambassador Serreta for the deaths and destruction that we're seeing in the Philippines at the moment from the earthquake. It's quite shocking. Australia welcomes the unanimous advisory opinion of the ICJ on climate change, and it really is a landmark opinion that has made an important contribution in relation to the obligations of all states to respond to the climate emergency, and highlights some of the human rights dimensions of the global challenge, which many of you have spoken to directly in your comments this afternoon. We remain steadfast in our commitment to working together with the international community to strengthen global climate action and to work in partnership with the Pacific and Southeast Asia. Australian Prime Minister Mr. Albanese was at the General Assembly just last week, the High Level Week, and he said, and I quote, "Australia is acting to meet the environmental challenge of climate change while working to seize and share the economic opportunities of renewable energy." And this is why we are beginning to co-host the 31st Conference of the Parties with our Pacific family. Nations for whom climate change is more than an environmental challenge, but an existential threat. So this discussion today is an important reminder of the need to integrate, uphold and promote human rights and all measures to address climate change, including at the UN General Assembly as foreshadowed by Ambassador Antes, Yules and Serreta. Thank you.
Thank you very much for your comments, Ambassador Walsh. I see Samoa, I think, raised their flag. Ambassador Tabitha Levy, please, the floor is yours.
Thank you very much. I'm most pleased to have co-sponsored the resolution that's sort of the advisory opinion on climate change. The advisory opinion is timely and welcome. At this critical juncture, in which the world is off track from the global target of the 1.5 degree goal, and we are experiencing firsthand the worsening effects of climate change. We appreciate the space provided to exchange this afternoon on implementing the climate advisory opinion from a human rights approach. And as Ambassador de Blue referred to earlier, moving from paper to action. I just wanted to bring to the attention, we took note that Vanuatu has submitted an amendment to the resolution on sea level rise and its effect on the full and effective enjoyment of human rights to amplify a key message of the ICJ advisory opinion that greenhouse gas emissions are primarily due to human activities, including by the burning of fossil fuels. It's really to emphasize putting paper into action. And the message is very clear, reinforcing the extensive scientific evidence and IPCC reports, and that we urgently need to curb emissions and phase out fossil fuels as we have agreed in COP28. So we call on members to support that effort, including friends in the room. Very much be able to.
Thank you very much, Ambassador, for your comment and grounding us back into the ongoing session of the Human Rights Council. Really, once again, really great silence. I'm very sorry that unfortunately we arrived at the top of our hour. I would really like to thank our panel, Ambassador González, Room, Yield, and Sereta, and Special Rapporteurs, Matera and Fuentes. Thank you very much for your insights. Once again, the ITJ advisory team is not the end, it's not the beginning. I see it as a stepping stone towards stronger climate action, and we look forward to continuing the conversation here in JR, in Belém, and in many other fora. So thank you very much for being with us today.
Thank you.
Since you're convening.